I'm Dr. Sridhar Mote. As part of the contract management lecture series for this YouTube channel, now I'm going to discuss about the topics on important provisions of contract. With around 35 years experience in government as well as in private, I have been teaching this contract management as a subject as a visiting faculty to the various premier and training teaching institutes. This deals with important provisions of Contract Act relevant to construction contracts. I also authored a book on infrastructure contracts and management, published by the renowned publisher Asia Law House, which book is available in Amazon.in, also available in online stores of Asia Law House, Flipkart also, which covers various topics related to the construction contracts, their management, claims, dispute resolution provision, any relevant topics for contract management. The takeaways from this lecture session will be: important provisions of Contract Act relevant for construction contracts, overall view of the Act consisting various provisions, emphatically study of the sections 1 to section 75 of the Act, which are relevant for the construction contracts, and also understanding the legal concepts and the legality of what are the lawful agreements, what are the criteria to be a lawful agreements, void and voidable contracts, performance, time as essence, breach of contract, damages and compensation act. These are some of the expected takeaways, lessons on important provisions of Contract Act relevant for construction. While going through this lecture, readers are advised to have the Indian Contract Act. A bare act means this act without any commentary. It is a bare act available in any law, public or legal publishing agencies. You can purchase a bare act and have it handy while referring the relevant provisions during the course of the lecture, so that it will be most useful for you. Otherwise, you can make a download of the Contract Act sites, and you can have Contract Act readily while going through the lecture for more benefit and more useful interaction. Because I'll be just referring the Contract Act relevant section and making some explanation. If you want to read it, the bare act provision, it is better to have a book with you while going through the lecture. All types of contracts, whether it is a construction contracts or a sale of goods contract, all types of contracts are governed by the same law, that is Indian Contract Act 1872. Not only construction contracts, day in and day out, you may be entering into some personal agreements also. You may be taking a house on rent, a lease agreement, you may be signing an insurance contract, purchase of a plot, agreement with a builder as a sale agreement, agreement to sale for purchase of a flat. So many things. All types of contracts, agreements are governed by the same act, Indian Contract Act 1872. As you can see, this act is 160 years old, enacted by the Britishers when they ruled our country. And our legal pattern and this act also is in similar lines and akin to English law, English Contract Act. Though it is 160 years old, still it is a relevant piece of legislation, valid, without much amendments, except 1 or 2 amendments. Still it is a strong piece of legislation. Many acts after the independence were undergone revisions, reenacted. This is only such act, still a valid piece of legislation with very few amendments. This act has 1 to 238 sections, which cover many aspects and various types of contracts. At the end of this lecture series, we will see what are all the contracts this act will cover, types of agreements. For present, now mainly we will focus on section 1 to 75, which is embodied in chapters 1 to 6 of this Contract Act, which provisions and sections are relevant for the construction. Before studying the Contract Act provisions, importantly, let us understand what are the three types of contracts that we come across normally. One is a works contract, means this is a construction contract, what we refer generally. This includes supply of materials, provision of labor, supply of labor, and also all machinery, and build a product. That is called a construction or an infrastructure project contract, called a works contract. Another type of contracts are sale of goods contract, means they involve sale of goods. Say I am purchasing some cement and purchasing some steel or any other type of materials, movable assets. In this, there is passing of title, means the goods possession, physical possession is also transferred along with the title of the goods. When I am transferring or selling to someone, the buyer will become the owner of the goods. There are certain taxation aspects also, transit and insurance provisions specific to this, whether I have to deliver door delivery or freight on board, delivery at the door. Likewise, there are transit, and in this transit, who is has to bear the insurance cost. Likewise, all type of transactions are governed in this. Another types of contracts are called service contracts, means purely service. I am engaging a design consultant who will be providing the design services. I am engaging a consultant for project management, all IT related services. So these are purely service related contracts. Earlier, before the GST, service tax was applicable for the service contracts. Indian Contract Act provisions are same for all the above types of contract, but based on the types of contract, the contractual obligations, transactions are different. Now our main focus is about works contract, means construction contracts, normally what we refer. Section 1 is an enactment. Section 2 of the Contract Act deals with definitions and interpretations. 2A says, when a person signifies his willingness to do or not to do, means to abstain from doing anything, he is said to make a proposal. To do something or not to do something, when a person proposes, that is called a proposal, means he gives his offer. When a person to whom proposal is made signifies his assent, means when he accepts, when he says yes, proposal is accepted. On acceptance of a proposal, it becomes a promise, means when it becomes a promise, it is a legally binding promise, means there is some legality. When a proposal becomes a promise, on acceptance, there is a binding contract. Now we will see what is the stage of acceptance, how the acceptance is communicated, so that together with this 2B, another act provisions will legally make a binding contract. Section 2E depicts every set of promises forming consideration for each other is an agreement, means an agreement is defined as a set of reciprocal promises. Both parties will make promises to each other. I will perform this, I will pay this in this time. Likewise, 2G of the Act defines an agreement not enforceable by law is void. So, if there is an agreement, if such an agreement is not enforceable, means if the law stipulates that such types of agreements are not legally valid, then court will not provide any remedy for such agreements. Such agreements are called a void agreement, means null and they are mere agreements, null and void agreements. So they are not legally enforceable agreement. We know the term null and void. So it is just mere an agreement, but not enforceable in court of law. An agreement enforceable by law is a contract. In the previous lectures also we have seen the difference between legally a contract and an agreement. A contract is an agreement which is legally enforceable. Otherwise, an agreement is a mere agreement, right? All agreements are not contracts, but all contracts are agreements. Agreements and contract. A contract is a subset of an agreement which has legal enforceability. This is the legal meaning and differentiation between the contract and an agreement. But in our day-to-day life, in sites also, in projects, generally construction managers, the field engineers have a tendency to use these two terms interchangeably and synonymically. No problem, we can use them synonymically, but one has to understand the legal differentiation between these two. An agreement which is enforceable by law at the option of one of the parties is a voidable contract. Now, here void and voidable has come. Voidable means the agreement is basically void, but one of the parties, though it is void, has an option to continue the contract. That is a voidable contract. We will see a little later when we study the chapter 2 of this Contract Act, void and voidable contracts. Now we will study the important provisions of Contract Act next. When an bidder submits his offer, who is also called proposer, he is submitting an offer to the owner, who is called an offeree, as an acceptor. Section 3, 4, 5 and 6 deal with communication, how the acceptance should be there and how the acceptance and communication should be there. Also, they specify revocation. So, communication of acceptance and communication of revocation is also stipulated, provided for by the contract. Proposal can be revoked and acceptance also can be revoked. Means how a communication can be made for acceptance or revocation for the proposal as well as for the acceptance. Means here basically an acceptance can be revoked, withdrawn. Also an offer can be withdrawn. Proposal means an offer can be withdrawn. We will see one by one. Section 4 deals with communication of acceptance. Here the communication of acceptance is twofold. Communication is complete when it is placed in the course of transmission by acceptor, like a post, fax. How the communication can be made? It can be made by post, fax, speed post, courier, whatever it is there, right? Today's in electronic world, email communications are also valid and recognized. When an owner places the acceptance, here acceptance goes like this. When the owner puts it in the course of transmission, then the communication is complete for the proposer. And when the bidder receives the acceptance, then the communication is complete again as the accept. As per the Contract Act, when the communication of acceptance is received by the bidder, the acceptance is complete again as the owner. Means when acceptance of the offer is received by the bidder, then there is a binding contract existing between the owner and contractor. A binding contract is formed as per this when the acceptance from the owner is reached and received by the bidder, right? Now revocation. A bidder can revoke his offer before it is accepted. For him, the offer of acceptance is when the owner puts it in the transmission. Means when he posts this, then for him the acceptance is complete. And a proposal can be revoked before it is accepted. Means before the owner puts this communication of acceptance in the transmission channel, before he posts or sends it by some sort or sends it electronically. Before that, the bidder has a right to withdraw the proposal. Offer means he can revoke it. Now you may say that what can it be revoked? Yes, legally, Contract Act provision for revocation of bid, but the consequences are, if the bid conditions stipulates that in case of revocation there will be EMD forfeiture. In that case, the EMD will be forfeited. Otherwise, it is permissible. And an acceptance, once it is given, also can be taken back. It can be revoked. Before the acceptance reaches the, suppose the owner has communicated his acceptance in a registered post. It takes 2 to 3 days, 3 to 4 days at least, you can say. Before that registered post reaches the bidder, the owner can revoke, means withdraw his acceptance. Legally, it is permissible, provided such revocation or withdrawal of the acceptance should reach him before the original communication of acceptance. Suppose I am putting it in a fax, or I am putting it in a speed post, so that it reaches before the original acceptance. The revocation of acceptance or withdrawal of acceptance should reach before the original acceptance communication. Then only the revocation of acceptance is permissible legally. So, section 3, 4, 5 and 6 deal with the modes of communication and how the acceptance and how the revocation of proposals as well as acceptance, both making and withdrawal, can be made. So, these are the eventualities. Section 7 is very important on acceptance. Section 7 of the Act says that acceptance should be absolute and unqualified, unconditional. The acceptance should be unconditional. Absolute means without any budging on the offer, fully as it is, the offer has to be accepted. Suppose I have given a proposal or an offer for 100 crores for construction of 100 numbers buildings. Without my concurrence, the consideration should not be, say, take half of the work and give only 50 crores of work award to me. No, that is not permissible. It should be full, absolute, as it is, and without any condition. Then only it is called a valid acceptance. So, on communication of a valid acceptance as per section 7, and when such acceptance communication is issued and received by the bidder, then only there is a valid acceptance. When this communication reaches the bidder, then there is a binding contract formed between the parties. This is the position of law. Next, we will see section 8. Now, acceptance means it can be explicit. One is issuing a detailed letter of acceptance or letter of intent, work awarding letter, whatever we may be called, express intention, stating that the work has been accepted. Now, the acceptance need not be through a written mode. It can be by conduct and performance of a proposal also. Means acceptance can be implied, conduct. How? Suppose without acceptance, an offer has received by me as an owner. Without acceptance, I am performing one of the next condition in that. Soon after acceptance, within a week, I can hand over the site, or within a week, I can sanction the mobilization advance. The owner, without acceptance, has performed the next in the agreement, means he has delivered the site to the, handed over the site, or as per the condition of the tender, he has sanctioned the mobilization advance to the contractor. Means by performance of a condition of a proposal, he is conveying his acceptance. Means it is a deemed acceptance, implied acceptance. So we can also say that that is acceptance by performance. Next, section 9 of the Contract Act deals with implied contract also. A contract can be in an express written form, where offer acceptance can be in a written form, and also the acceptance is written form. Contract documentation is written form. But there are certain implied contract, means based on the conduct of the parties, offer and acceptance are deemed. Likewise, suppose I am standing at the bus depot A conductor in a bus came to close shouting that if you pay me 20 rupees, I'll take you to the designated place, say Amirpet. He is giving a general offer. By hearing the words, suppose I am entering into the bus, means I am conveying the acceptance to his general offer, so that there is a contract is formed between me and the bus conductor, so that he has to take me to the destination provided I pay him 20 rupees. Likewise, in an eatery in a hotel, where the menu is displayed with the rates, by seeing that I have ordered a eating food item, so there is a implied contract formed between me and the hotel owner for providing the food items at the designated rates. When I eat it, I have accepted his offer, then I have to pay him. So there is an implied contract. So these are the implied contracts which are envisaged in the Contract Act. The court or an arbitrator or a judge will infer whether there is an implied contract existing between the parties or not based on their conduct. Offer acceptance are deemed by the conduct of the parties. Next, we will study one of the important topics. It is on voidable contracts and void agreements. We will see what are the voidable and void. Means void agreements are legally not enforceable agreements. They are called null and void agreements. They are mere agreements, not contracts. But as per section 10, the criteria are specified which types of agreements are legally enforceable, legally valid agreements. Means these agreements have to be made with free consent of parties. Means law assumes that the contracts are entered between two parties with free mind, without any influence, or without any with free will and free mind, without any force or without any influence, really having the full knowledge of the subject, they enter into a contract, so that is a validly legal agreement. And for a lawful object, means your object should not be unlawful. Means for forbidden activities by law, you should not enter into contract. Suppose you cannot enter into a contract for planting a bomb somewhere, or terrorist activities which are forbidden by law. So consideration and object should be lawful. And again, for example, we will see also, one cannot enter into a contract with a minor below the age of 18 years. And one cannot enter into a contract when a person is in alcoholic influence, because he doesn't have any consent. What is the subject matter? He is not aware while he is in a drunken mode. So these are sort of the consideration we will see next. When an agreements are made like that, then they are void agreements. Now, what are voidable contracts? Though the agreement is void, one of the parties, means mostly the victim who has been subjected to some influence, has an option to continue the contract, not the culprit. Only the victim has an option to continue the contract, declare it as an enforceable agreement, and he can continue the contract in certain specific cases. So a void agreement, at option of one of the parties to declare it as a legally enforceable contract, and he can continue the contract. They are called voidable contract. Not every void agreement is a voidable contract. There are certain provisions also. Only in certain cases, void agreements can be made voidable contract, means they can be enforceable legally at the option of one of the parties. That is a difference between a void contracts and a voidable. Section 11 says, defines the age, major in age. Who are the competent to contract? That is given in under section 11 of the Contract Act. He should be major in age, means law assumes that a person below 18 years of age has no mental capacity to enter into an agreement. He can just without any maturity, he can just make enter into a commercial agreement for a throwaway prices. Suppose for a bunch of chocolate, he may try to transfer the property on his name. Law assumes like that. So a person has no mental maturity to make a commercial transaction below the age of 18 years. That is a position of law. And sound mind. A person may be may not be having a pagal hai, matlab he is mad, he doesn't have any sound mind, then he is disqualified because he doesn't know the subject, he is not, and has no mental. But there are persons called lunatics. At certain times they have a good mind. During that time one can enter into an agreement. So these are some of the competency of the contract. And also, a person entering into a contract should not be disqualified by any law. Suppose a person who is already bankrupt, has no financial standing, then he cannot enter into a contract for a commercial transaction. He is debarred. So he is disqualified by way of his bankruptcy. Now, Section 12 defines what is a sound mind. Section 13 of the Contract Act defines consent, means understanding the same thing in the same sense on the subject. So both parties, it is called legally consensus ad idem, means identity of minds. Both persons understand the subject matter of the contract in a same way. Just I'll give an example. I am having two types of cars. One is Maruti and another is say Santro. I am trying to sell my Santro to you. I have two cars, but you are assuming that I am trying to sell my Maruti, whereas my position is to sell my Santro. So there is no meeting of minds between us. So there is no consensus item. You are thinking differently on the subject, I am thinking differently on the subject. There is no identity of minds. So when there is no consensus ad idem, means there is no meeting of minds. This is, even if you enter into a contract, since there is no clarity, that contract is void. If it is proven there is no consent, then the contract is void. Section 14 of the Contract Act defines free consent, means a person should enter into a contract with free will, without any free mind, without any coercion, threat, fraud, undue influence, misrepresentation. If it is proved he is entered into a contract by any such act, then such contract is a void. Section 15 defines coercion and threat. It is as per Indian Penal Code, it is a type of criminal offense. Threat means you can coerce, or you can also threaten the persons with dire consequences. You can pistol, threaten, so many things. That is a Section 615. So if you put a pistol and threat a person for signing an agreement for any transaction, it is a void. Undue influence. Law assumes that when both parties to the contract are there, by way of the relation, one party can influence the will of the other person by way of their dominant position. Suppose a lawyer and a client is there. A lawyer is in a client, the relationship, a lawyer can influence his client because he is a lawyer and he knows many law points. So many cases he is handling for this client. Likewise, a doctor and a patient, a master and a slave, an employer and employee, a father and a son. Law assumes that one of the person can influence the other person by virtue of his dominant position. So if one can prove that the agreement was signed with undue influence, then such agreements are void. One has to prove it, not mere allegation, right? Now, fraud. When fraud is a charge of BC, what we can say. Intentionally, you suppress some fact or some major information on the subject and you try to cheat the other person by misrepresentation. That is called a fraud. Fraud is also a criminal offense. If one can prove that by fraud that agreement has been entered, it is a void, right? And it is a voidable also. Now, under all these circumstances, these agreements, though void, are voidable. Means what? Suppose I have threatened you to sign an agreement. Later you realize that even that agreement you can enforce and the reasonable consideration you are receiving. Then you can declare as a enforceable agreement. I don't have an option. That is a voidable contract. So in case of these eventualities, the victim or one of the parties who has been subjected and whose consent has been obtained by one of these means can declare it as a valid contract and enforce such a contract. That is called a voidable contract. But if you are entering to a contract with a minor in age, it is a purely void contract. No party has an option to continue. That is a void contract. If you are entering to a contract with unsound mind person, it is purely a void contract. Law does not permit it. But in case of this cohesion thread section 16, 17 or 15, then one can declare it as a voidable contract and enforce it. The victim, not the culprit. Misrepresentation is dealt in section 18 of the Contract Act. Misrepresentation means misrepresent the fact or a provision on the subject matter of the. Now, when we speak of the misrepresentation, you can just have an idea. In a construction contract, in the bid documents, there will be a data supplied, say a soil profile or some sort of borewell data or some site data. Some will be provided. What they say, they reserve that. Though this data or information is provided, or this investigation reports are provided, these are only provided for just information. The bidders are required to do their own investigations and ascertain the investigation, authenticity of the site particulars. Means what? They are providing the information, so it should not be construed as a misrepresentation of the fact. Suppose tomorrow its particular location at the site, the investigation report may go wrong. There may be some different strata. To surmount this, what they say is only indicative. The bidders are required to do their own investigation. This is the reason, to avoid such eventualities of misrepresentation, such a condition is given in the. Now, section 19 is voidability of agreements without pre-consent. Section 19A is voidability on consent by undue influence. Means all this consent are say 14 to 19 classes. When there is a lack of pre-consent or say coercion and threat, even undue influence, the victim has an option to, they are called voidable contract. The victim has an option to continue the contract, making as a legally valid, but he has to give a communication. Though it is void, I am ready to perform it. Please enforce. He has to give a communication to the other party. We will see how a communication on voidability can be given at a later stages. Section 20 is agreement is void where both parties under mistake are a matter of fact. So there is no proper subject understanding between the parties. So when there is a bilateral mistake or a mistake of fact, agreement is void. Section 21 says mistake of law is not voidable. Suppose you don't know what is the law provision, but you have entered into an agreement concerned law. So ignorance of law is not excuse in legal terms. Means you are supposed to know the subject matter of law. So ignorance of law is not acceptable. If there is a mistake of law, it is not voidable. If there is a unilateral mistake by one party, it is not voidable. Means it is the duty of the party to have a fact assessed himself with a due diligence. You cannot say that I am not aware of this fact. This contract is voidable. No, you cannot. At the most, if there is a element of any threat or say undue influence or fraud, then only one can go for that. Otherwise, mistake of a fact by one party is not result in the voidable contract. Section 23 stipulates what considerations and objects are lawful. Means there are certain considerations. Means legal lawful objects and lawful considerations. Means one cannot go for any unlawful activities, make an agreements for unlawful activity. Only that object should be lawful. Agreements, section 24 stipulates agreements void if considerations and objects are unlawful in part. Right? Section 25 is very important. It says agreement without consideration is void. Means an agreement should have a consideration in a reciprocal promises. Suppose if I am performing, in return I have to get something. Suppose I am selling my car to you. In return, I must get certain monetary consideration, or it need not be purely monetary consideration, but it should have certain monetary consideration in the eye of law. So without any consideration, it is void. Suppose I am selling my car without any consideration. No, it is void. And the consideration need not be adequate. Suppose the market value you may be saying 5 lakhs, but I'm just giving it to you 2 lakhs only. No, cannot. It can be. It should have some sort of monetary consideration in the eye of law. It need not be adequate, or sufficiency is not the subject matter. Section 26, 27 and 28 deal with agreements in restraint of marriage, trade, legal proceedings void. You cannot make it an agreement so that you should not marry concerned so and so, and you should not enter into a trade in this region, or you should not go to court in case of disputes between us, or at least there are so many jurisdictions, at least one court should have the jurisdiction to entertain any sort of disputes or for redressal of any contractual matter. You cannot make that no court shall have the jurisdiction on this. So these are some of the agreements which are void. Agreements are void, section 29, for uncertainty. Suppose without any certainty I made an agreement. Say we both entered into agreement for supply of 100 kgs of oil. Is it perfect? No. Oil, I'm saying there are many types of oils available in the market. Is it a groundnut oil? Is it a peanut oil? Or is it a sunflower oil? Nothing is specified. So there is uncertainty. Such uncertain agreements without certainty are void agreements. Wagering agreements means there are certain agreements, just like on the outcome is not certain. Likewise, cricket betting is there. Suppose if you make a betting, if India wins, I'll pay you. Such agreements, betting agreements, wagering agreements are not legally recognized. They are void. But in certain cases, horse trading is permitted in law in certain matters, right? So wagering agreements are void. Contingent contracts. Chapter 3 of the Act deals with contingent contract. Means these are the contracts to do or not to do something on occurrence of a specific event. So such contracts can be enforced only on occurrence of the event. Before that, not. Now, when such event, defined as a contingent event, becomes impossible, then it can be enforced. When event of contingent contract is impossible, then it is void. If the event is tagged within a fixed time, then agreement becomes void on expiry of time. In case the event is not happening that time. Suppose I make an agreement. Within next week, if the rain happens, if it rains, I will do this. Suppose if in the next week, if there is no rain, or if there is next week has expired, then this agreement becomes void. So these are just contingent contracts legally. Chapter 4 is very important, that deals with the performance of contracts. Section 37 is on obligation of parties. Parties have to perform their promises unless exempted by any law. Suppose I have to build something, but constructing such building is now prohibited, or a law has passed with environmental regulations, I cannot make. So then I am exempted from performance, because it is not, when we contracted it is all right, but now it is not legally permissible. Performance is excused. Also, this section says promises bind their legal representatives in case of death of a promiser. So a contract entered has to be performed by their legal heirs. Section 38 deals with effect of refusal to accept offer of performance. Suppose we entered into a contract, I am ready to perform and I have given a notice, yes, I am going to supply this material to you as agreed. If you are refusing, means I need not perform. Effect of refusal of a party to perform wholly. Then in case, suppose you are refusing to accept my performance as per the contract, then I can put the end to the contract, and also I can seek some compensation. This is position. Section 40, person by whom promise is to be performed. Suppose if the nature of the contract and transaction is, it has to be performed by a particular person. Performance should be done by such particular person. Section 41 deals when a performance is accepted by a third person, then the original person is exempted from doing. Suppose A and B have contracted. Instead of B, A has accepted the performance from C. Then A cannot legally catch B so that you have not performed, because he has accepted performance from a third party. Section 42 to 45 of the Contract Act deals with joint promises, joint liabilities, and joint rights. Just in a case, we would have seen some joint venture agreements. Not the joint venture agreements are covered only these three provisions, but joint promises and joint liabilities, joint rights, they are dealt in this. When a joint we would have seen joint venture, jointly and severally the parties are responsible for performance. The promisee can enforce against either a single person or a jointly all the persons, or even if he leaves one person from performance, other parties should not be just absolved of their responsibilities. So these are the joint liabilities, joint rights are dealt in this. Section 46 is very important. It stipulates that when no time is specified for performance, then it should be performed in reasonable. Suppose in a construction contract, everything is there, but completion of work is not specified. We have made a contract, right? Construction of so and so numbers of, but time is not specified. Then it should be completed in a reasonable time. What is the reasonable time? Court will decide it. What is the nature of the building or a type of project? What is the industry standard? Likewise, then it should be done in reasonable time. Section 47, time and place of performance. When time is given, but place of performance is not given, means in the usual business working hours, if it is a delivery and it is a place of performance as envisaged under the contract, it will be performed. Application of performance or certain day to be at proper time and place. If the place is not defined in the contract, the person performing, that is a promiser, has to apply to the promisee and inform that he is going to deliver it such place. With his concurrence, he can deliver our place of performance. These are likewise place of performance when an application has to be made and no place fixed performance, then it should be applied and sanctioned by the promisee. Likewise, these are some of the conditions. Next is reciprocal promises and performance. When there are reciprocal promises, means both parties make a promise against each other performance, and one person's performance is dependent on other person's performance, just like in construction contracts. The owner has to give the site, then the contractor can start the work. Owner has to release the payments, then contractor can do the work with the cash he receives periodically. Likewise, promiser not bound to perform unless the reciprocal promisee is ready. Suppose a owner is not in a position to give the site, so he cannot ask the contractor to perform. A contractor is excused for performance. Order of performance of reciprocal promises. If in the contract the order of performance is given, then in the same order the performance has to be accomplished. Next, liability of a party preventing event. Suppose in a contract I am ready to perform, but the other party is not allowing me to perform, then I need not perform. Also, I can claim compensation. Effect of default of a promise of performance consisting of reciprocal promises. Same thing is Section 55 of the Contract Act, which deals with where time is essence and where time is not essence. Very important provision of the Contract Act relevant to the construction contracts. It first says effect of failure to perform at fixed time in a contract where time is essential. Means in which contracts time is essential, the contract has to be performed in the time. If that is not performed in the time, the contract can be voidable, means it can be avoided. When a contract in which time is not essential, the performance cannot be put an end by the promisor, means in which the time is essential, you can terminate the contract. In which time is not essential, one cannot put an end to the contract. Only he can seek the damages, he can seek the compensation. Now, what does it say? Whether time is not essential or not, mostly it depends upon the terms and conditions of the contract. Just for an example, if a contract is having an extension of time clause or a LD clause, fundamentally it looks that time is not essential because there is a provision in the contract on accepting a delayed performance with LDs, or for owner caused delays or some sort of delays, there is a extension of time provision. So whether time is essential or not, whether the parties have agreed or not, or what the contract position says, intention of the parties is judged. There is a good judgment in the Construction Company and State of Maharashtra, AR 1979. You can just refer this. It deals with this topic, whether time is essential. Generally, in construction contracts where there is a LD provisions or say extension of time provision, endurance sanctions, then time is generally not regarded as an essence. Just in a legal sense, I am telling it. Otherwise, time essence or not can be made subsequently by suitable communications. Now, if a performance other than the time is agreed upon, suppose I have to complete the work in 2 years. If while accepting the delayed performance, if there is a proper notice is not given regarding my intention to claim compensation, I cannot claim compensation. This is the reason while giving a provisional election, there is a rider clause given in that. Means this extension of time is granted provisionally, reserving the right to levy the liquidated damages. This is the standard words used by the project owner. Just to say that I am not accepting the delayed performance, I am reserving the right, and it is only provision. I am reserving the right to levy the liquidated damage. This is the wording. So if I accept the performance, delayed performance without any demur, I have accepted it. I cannot claim a compensation later unless I state it while accepting. Section 56 is agreement to do impossible acts are void. Means suppose I am making a impossible, physically impossible act, that is a void. Or impossibility can be legally also. Suppose we have contracted for demolition of a building. After making an agreement, within a few days, the building automatically got demolished due to an earthquake or some act. Then the purpose of the object of making into a contract has become impossible. Already building collapsed. Then there is no need to perform it. That is called a object is frustration. Such contracts are called a void contract. But remember here, commercial impossibilities are not recognized as per Indian law under this provision. Only legal and physical impossibilities. Something was physically possible, but later physically it is impossible. Then you cannot perform it. That is called a frustration of object and void. Section 57 and 58 deal with reciprocal and alternative promises where one branch only legal. Means in such cases, in reciprocal and alternative promises, where only one branch legal, other branch illegal. So only legal branch is valid and other part is void. Only that part can be enforced. Other part illegal, means not enforceable, void, partly void to that extent. Section 59 to 61 deal with appropriation of payments. Means when there are multiple debts and the person is paying to the other person without specifying any debt. So the person has a right to appropriate the amount received how can he appropriate against each debt when it is specified or not specified. It is not much relevant to the construction contracts. Just if you are interested, you can go through this section. Section 62 is on effect of novation, recession and alteration. What is a novation? Novation is substitution of a original contract with a new one. That is called a novation. Recession means rescind the contract, terminate. Alteration means also you make some modification to the original agreement and make a altered agreement. In cases, original agreement need not be performed. Only one can perform the novated contract or a substituted contract or a altered contract. In this, original contracts need not be performed. Only novated contract, substituted agreements need to be. Section 63, promisee may dispense with or remit performance of promise. Means I am the owner. You have promised me to make something. I am a promisee, you are a promiser. I can excuse you. I say no need to promise, right? I can dispense with. Or I can accept partly the promise and partly I can say no, your performance is complete. Yes, I can declare it. Section 64. When we have just studied the voidable contract. In a voidable contract, when the contract is rescinded, what are the consequences are here in this. And in section 64 and 65 specify that if a person has received any advantage under void agreement, he has to restore it, he has to return it back, even in void agreement. But when a voidable agreement is declared as an enforced agreement, the party who is electing that option to continue such agreement has to communicate to the other part. Look, this is a void agreement, but because of this, I am continuing this. You have induced into a undue influence, or you have threatened, and this is a void agreement, but as per this section, I am continuing the contract since it is a voidable contract. Such communication, it should be as per section 4 of the Contract Act. He has to communicate to the other person, or also he can revoke his rescission also, voidable contract, or he can declare to continue the contract. When a promisee cannot give a promiser the reasonable facilities performance, it is excused. Now section 68 to 72 under chapter 5 deal with certain relationships resembling those created by contract. Means there is no contract, but based on certain the conduct of the party, it is assumed that as an implied contract. For example, just for a matter of example, this is not related to construction contract. Suppose an unsound mind person is there, or a minor is there. A person has supplied some necessities to that fellow. Means when property of that minor or say unsound person is there, he can claim from the amounts of that against the preliminaries or necessities supplied. Though he has not entered into a contract, legally he is entitled to receive such the amount spent on this, because the law assumes that these relations resemble those of a contract. There is an implied contract in that. Chapter 6 is very important, the sense of construction contracts. They deal with breach of contract, consequences, damages. Please go through a good book also. Not only this, I recommend you go through a good book on Contract Act. Very good authors are available in market. You purchase a book. You just go through each and every section from 1 to 7 for having a better understanding, specifically on this breach and damages. What is a breach? Breach of contract is a word you use quite often. When a condition or a promise has been broken, not honored, then breach of promise, vada todna, means breach of a promise, means that breach of a condition is breach of a. As per this section, when there is a breach, the party suffering the breach is entitled to claim a damage by way of compensation from the other party. Breach causes damages, and against the damages, legally a party is entitled to claim compensation. Section 73 says so. And also this section 73 says the breach entitles compensation, but compensation is only for the direct loss. Suppose you cannot say that has this been done, I would have earned somewhere. No, that loss should be direct and it should not be a remote loss. Remotely means it should be certain and provable, then only the loss be compensated towards the damage. Section 74 says where penalty is stipulated for, not exceeding that amount, penalty or that can a compensation be made. Means generally there are liquidated damages in the contract. Means they are considered as a pre-agreed, genuinely estimated damages. So without challenging the quantum, a party suffering the breach, say a project owner, can claim the LDs in case of non-performance for the particular period as agreed. Section 74 of it. And section 75 says partly rightfully rescinding the contract is entitled for compensation. In case of non-performance, then a party, both the parties, any party can terminate the contract and seek the compensation for the damages from the other party. So generally, in case of delays by the project contractors, the owners will claim the LDs as stipulated as a remedy, because the LDs are mostly stipulated in the. In case of owner caused delays, the contractor will claim the compensation because nothing is specified mostly in contracts. They claim the compensation against breach and contract under Contract Act. They say that generally they claim overstay compensation or prolongation cost. 2 years was the stipulated time. We worked with two more years at the site. So this expenses, overstay or prolonged stay, compensation by way of machinery, manpower cost, overheads, loss of profit, likewise claiming as per these provisions. Now we have seen the important provisions, section 1 to 7. Please go through a good book for detailed understanding. Understand better, because in this only say 45 minutes to 1 hour lecture, one can only cover the overview. We will see other provisions of the Contract Act, what they say, just what means section 1 to 238, what other provisions say. Section 76 to 123 Act is replaced by Sale of Goods Act 1930. Separate legislation is made because this act originally was 1872. In 1930, it is replaced. Otherwise, all are combined. Indemnity and guarantee, because there will be certain contracts of guarantee, surety. There is called a principal debtor, creditor. You will be maybe signing a surety somewhere. All this, there are also agreements are governed by these sections. Bailment means, suppose you are giving the product to someone for turning it. I am giving some steel to a fabricator for fabricating and hand over the finished product to me. Then I am giving a clothes to a tailor for stitching and giving to me. They are called bailment. The title is not transferred for a particular purpose of a goods. I am handing over the goods so that he will do something and give a finished product to me. What are the rights and liabilities, responsibility of the parties during the bailment is dealt in 148 to 170. Likewise, pledge, hypothecation, these matters are dealt in section 170 to 181. There is one more commercial transaction and types of contracts called agency contract. I am a principal. I am engaging a third party as my agent to do certain business transactions on my behalf. He is called an agency. He is entering into an agreement and contract on my behalf as an agency. He is representing me as a principal. I am called a principal. What are the agency principal relations and what are their rights, liabilities, responsibilities? All are dealt under section 182 to 238. They are called agency principal relations and such agreements. Earlier, Section 239 to 266 of the Act was dealing with partnership agreements also. Now, the partnership deeds and agreements are held under Indian Partnership Act. This is also enacted by in 1930. So, these provisions are now invalid and these provisions are now replaced with Indian Partnership Act enacted in 19. So, this is all about the Contract Act provisions, Section 1 to 75, mostly relevant for construction. For any support or help in contract management or infrastructure contract management, you can reach me at this email ID. Please keep watching this YouTube channel on contract management lecture series. Also, please popularize this channel, contract management lecture series, which covers various topics on contract management.